Pursuant to section 2705.05, a hearing is required in all contempt proceedings. At that hearing, the court shall investigate the charge and hear any answer or testimony that the accused, in this case Ms. Mullen, makes or offers. If the accused is found guilty, the court may impose any of the following penalties. For a first offense, which this would be, a fine of not more than $250, a definite term of imprisonment not more than 30 days in jail, or both. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You are Dakota Mullen.
Yes.
Correct? Ms. Mullen, you were served personally with a subpoena by the court bailiff on May 29th, 2025 in the case entitled City of Conditional versus Ann Headley. Is that correct?
Yes.
You were ordered by the subpoena to appear on June 4th, 2025 at 1:00 p.m. Do you recall that?
Honestly, with all the subpoenas I've gotten over the past month and a half, I do not recall.
I don't want to hear that, Ms. Mullen. I don't want to hear it.
I understand.
She was the victim in the Headley case, right? Or alleged victim?
Yes, sir.
Poor excuse, Ms. Mullen. So I want to know why you weren't here that day.
I cannot,
Tell me the truth.
I truly cannot recall the day, but I'm sure it was probably a day where there was Todd's case the day before, or the day after, or 2 days before, 2 days after, and I just mixed it up. I don't know. That's all I have to say.
I don't recall, Mr. Lewis, did Ms. Headley's case got dismissed, right? Because of Ms. Mullen's failure to participate or appear?
No, Ms. Headley's case we're having a hearing on it today, Your Honor.
Oh,
Yeah,
maybe that's why I scheduled it
it's
today.
it's scheduled for a final pretrial today.
Okay.
Yeah,
What time is it scheduled?
1:30, Your Honor.
Notice what the judge does here. He doesn't immediately punish her. Instead, he defers action until after seeing whether she cooperates in the ongoing case. That's actually a strategic move. Judges often give one last chance for compliance before imposing contempt penalties. It's a blend of authority and restraint. He's saying, "Prove to me you're serious," or "face consequences." It's a subtle but powerful moment of judicial discretion. Would you call this mercy? Or a calculated warning shot?
Well, Ms. Mullen, you're not going anywhere because I'm going to defer. I'm not going to take action on on the contempt until I'm assured from Mr. Lewis that you are actively cooperating with him. What your decision about how to proceed on the Headley case is between you and him. I'm not telling you have to proceed in a certain way or not. But I am directing you to cooperate, and that's what a subpoena is for. You are to cooperate. You are to be here when you're supposed to be here. I will address the contempt proceeding here shortly, and we'll see what happens. So you can go back into the area where victims are normally located until Mr. Lewis needs you, okay? Okay. The court is back on the record in City County versus Ann Headley, as well as in re failure to obey subpoena of Dakota Mullen, 25 MIS 10. I took a recess on this case to allow Ms. Headley's case to go forward. Ms. Mullen was issued an order to show cause as to why she should not be held in contempt of the court for failing to obey a court order to appear on June 4th, 2025 in the Headley case. Before I proceed, I'm going to ask Mr. Lewis. Mr. Lewis, did you find Ms. Mullen's participation to be cooperative?
Yes, Your Honor. Today's participation, she was cooperative, yes.
Okay. What's your position with respect to holding her in contempt of court because she forgot or she really didn't have a reason other than too much going on? I'm not sure.
Your Honor, I agree with the court's decision to go forward with this miscellaneous charge, and I think that she should be held in contempt of court. She did not give a reasonable excuse other than she just forgot or was confused for not appearing. Thank you.
Thank you. Okay, Ms. Mullen, you are still under oath. What would you like to say in response?
I'm pretty sure I just had the traffic court and all of these, and it's no excuses. I have no excuses.
Are you high?
No, I'm just really upset now. Because hearing my mom's payments and then my fines and my previous fines and finding some money in it and everything like that, it's just hard to, without me being able to find a job and no other income other than return, it's a lot to think about right now.
Well, we've had some experiences with you, Ms. Mullen, over the past month or two, and you testified recently in another case. I can't remember which case it was, but it seems like you've appeared before this court quite often here in the last few months in different cases, and I just don't like your appearance.
Here comes the verdict: contempt of court. The judge sentences Mullen to 30 days in jail, suspended, no fine, no costs, but with a condition: she must submit to a drug test. This is smart judicial design. By suspending the jail time, the court keeps leverage. If Mullen slips up again, those 30 days become very real. It's accountability with an escape hatch, a classic one more chance sentence. Fair or too lenient? Let me know in the comments.
I'm going to hold you in contempt of court for failing to appear on June 4th, 2025. I'm going to suspend 30 days of jail. I'm not going to impose a fine. I will waive court costs, but I am going to order today that you submit to a urine drug screen, and I am going to, once I see the results of that urine drug screen, call you back into the courtroom, and then we'll decide to complete the sentence with respect to probation. Okay, so you're going to submit to a urine drug screen today. Anything further, Mr. Lewis?
No, Your Honor. Thank you.
Ms. Mullen, there will be someone who will assist you in that respect. Thank you. The court is back on the record in failure to obey subpoena on Dakota Mullen, case number 25 MIS 10. For the record, the court has been recording these past few hearings involving Ms. Mullen under the and heavily bookmark. So I made a mistake on that, but we are back in the courtroom to continue the sentence. Ms. Mullen is in court without counsel. Also present is Law Director John Lewis. When I found you in contempt of court, Ms. Mullen, I imposed a sentence of 30 days jail, suspended. I waived a fine. And before I completed the sentence, I ordered that you undergo a urine drug screen. The results did match what my suspicions were. You tested positive for ecstasy, benzos, amphetamines, methamphetamines, and marijuana. Are you currently receiving the treatment services of any substance abuse or mental health agency?
I was working with Signature Health. after I got out of the hospital in December. I did not follow through. But I'd like to go back to them if I get recommended.
Anything further, Mr. Lewis?
No, Your Honor. I suspected that she did, and you were correct.
Okay, I will, as I said, I'm going to place her on supervised probation with this court. I'm going to order that she submit to a comprehensive diagnostic assessment at Signature Health and successfully comply with any recommended course of treatment. She's ordered to remain drug and alcohol free. She's not to possess or consume any alcoholic beverage or drug or abuse. And she's not to go into, that includes as well pseudoephedrine products, and she's not to go into any bar or liquor establishment for the term of her supervised probation, which will be 2 years. She will have to pay the probation fee and costs, and I will give her until December 31st to pay all costs in this case. I'm advising Ms. Mullen of her right to appeal, without cost, of her right to have counsel appointed on appeal without cost, of her right to have documents provided her necessary to file an appeal without cost, and of her right to have a notice of appeal timely filed on her behalf. Okay, Ms. Mullen, over the next 2 years, you're going to be on probation with us. You're going to be meeting with the probation officer periodically, and he's going to be monitoring your compliance with my sentence. If over the course of the next 2 years you're found to have violated in any way the terms of your probation and sentence, in this case, you do face up to a maximum 30 days in jail. I could extend your probation from 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already done. So do you understand the consequences you face if you're found to have violated your probation?
Yes, sir, I do.
Yes, go ahead.
So, to wrap it up, Dakota Mullen was held in contempt for failing to obey a court subpoena. Her 30-day jail sentence was suspended, but her drug test revealed multiple substances, leading to 2 years of supervised probation, mandatory treatment, and strict no-alcohol conditions. This case perfectly captures the clash between personal chaos and judicial order, showing how even minor legal missteps can spiral into major consequences. It's a reminder that the justice system can be stern, but also compassionate when it sees potential for reform. If you found this case as shocking as we did, make sure to hit that like button, drop your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns just like this one. Because in the world of law, truth is stranger than fiction.